Welcome to Simplifying the Complicated. In each episode, we'll get together with other professionals and have fun talking about trust and estate matters. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, lawgbs.com. Now here are the hosts of Simplifying the Complicated, Lori Bolander and Lauren Gallagher.
Hello, I'm Lori Bolander.
I'm Lauren Gallagher.
And welcome to Simplifying the Complicated, the show where we talk about trusts and estates and related issues. Today, we're going to simplify the complicated around landlord-tenant issues, specifically as they relate to trusts and estates. These arise in our trusts and estates for, in our cases, usually when we're representing a trustee or an executor, or maybe even somebody as power of attorney, and also, in probates, a probate administrator. Usually it involves somebody in this property that is not supposed to be there and will not willingly leave. Luckily, we've found an attorney, Lawrence Mudgett, to help us with those issues. Lawrence practices in the area of landlord tenant law, also bankruptcy and real estate law, and knows all the ins and outs of how to deal with these situations. So welcome, Lawrence, and thanks for joining us today.
Absolutely. Thank you for having me.
Yeah. Do you want to tell us a little bit more about yourself and your practice?
Be glad to. So I've been doing, as you said, landlord tenant law, real property litigation, not so much bankruptcy anymore. I used to do more, but I'm still kind of versed in that world for about 18 years now. I do business as Safer Law, professional corporation, and have had my own firm since 2009. I started out on the tenant side of the aisle because it kind of went hand in hand with bankruptcy. Every bankruptcy seemed to have an eviction or a foreclosure related to it. So rather than farming all that stuff out, I started taking it on. And as my practice grew, I made a lot of good associations with other knowledgeable and skilled attorneys, really learned the trade, and now do almost exclusively landlord-only work. I'll take on tenants every now and again, usually commercial, sometimes residential if it's the right facts and or circumstances. And I've handled thousands of these. I'm intimately involved in the case from start to finish, so I'm very familiar with the process from that initial notice and kind of diagnosing what's going on and what needs to be done, all the way through the sheriff's lockout.
Yeah, and we know this because we have worked with you on many of these, yes. And you're also just a wealth of knowledge on all of the obviously state rules, but local rules and all the ins and outs of what's happening, especially in the last, however many years when we had COVID and everything was changing all the time. And there's still some variances between municipalities in San Diego. I know you're just very well-versed in all of that and keep up with everything that's going on. So I think it's a real asset to, any landlord that is dealing with these issues. I thought we would start with kind of what's maybe a more simpler issue than what we might get into in a little bit. But, what about a situation where somebody's passed away or is, somebody's living in a house that you're in control of as trustee or power of attorney, and you have an actually paying tenant, and now you're in control? Are there steps that person should take regarding this tenant and how things are being managed and operated?
What happens if you've got a tenant, they're paying rent, owner dies, there's a trustee, or maybe, a successor in interest has inherited the property, what do you do? So the first thing I think is you need to let the tenant know that you're now in charge. And you do this with a notice of change in management. It's not a complicated form. It's Civil Code 1962. That's correct, 1962. And you basically just need to tell the tenant, hey, I am so-and-so. I now am in charge. This is where you pay the rent. Here's a phone number to call in case you have a maintenance request. And you also have to give an address for the purpose of serving and receiving notices, right? So when the tenant sues you, they have to know where to go serve you. That's really the first thing that I would do in a situation like that. And there's an important reason why, and that is, if you don't do that, then you cannot serve a notice to pay rent or quit. So if your tenant tries to take advantage of the situation, oh, I didn't know who to pay rent to, so I just didn't pay anybody. You wouldn't be able to do an eviction for that. You would still have the right to collect the money, but until you serve that notice of change in management, you wouldn't be able to proceed for non-payment or even holdover damages if you, say, gave like a 60-day notice or something like that. So that would essentially be the first thing I would do if I was taking over. And then I'd also scour the records. A lot of times the deceased, maybe they had kind of a shoot from the hip style relationship with the tenant, so to speak, and there isn't a written lease, there isn't a ledger, but maybe there is. So the better document history you can put together to kind of validate how things had been going and where you're at, the better. So
yeah.
So in that situation, would you, I mean, let's say the intent is to sell maybe 4 months, 5 months down the road. Is it worth it to try to enter into a new agreement if it was that kind of casual relationship with the decedent? There wasn't a lease, or it was 10 years ago and they're still there. Is there a benefit to having a new lease, or does it help to not have one?
It really depends on the facts. I would say most of the time, probably not go into a new contractual relationship. If your intent is, like you said, to sell, there's something called an 827 notice on a month-to-month agreement. So if that tenant is month-to-month, which most of them, when these come up, they are, maybe there's an old lease and the time frame on it is expired, but they're still paying rent each month, you can serve what's called an 827 notice. And basically, the tenant doesn't have to countersign that, and the terms that you put into that notice would be incorporated into the lease agreement in 30 days. So most of the time we see those notices like to increase rent. But you could do that, say, on a month-to-month where you had an outdated lease, to maybe claim the exemption from just cause, or reserve the right to evict because you want to sell for owner occupancy. That has to be reserved specifically in the lease agreement under the just cause statute. So those are things you could do in lieu of trying to get somebody to sign a brand new agreement.
And those notices, I think, or just cause, I think we've been through this before, but the owner dying and needing to sell the property to administer the trust is a reason for just cause.
Right.
Yeah.
That would be withdraw from the rental market. And that is a valid just cause reason for the eviction that you wouldn't have to specify. But if you were doing it because, say, the son intends to move in there or something like that, then that would require, you would have to explicitly reserve that right.
Got it. So moving to something a little more complicated, which is a lot of the times where we're dealing with you. You take over, somebody passes away, you take over, and somebody's living in this property that should not be. A lot of times for us, is it is like an adult child that never has left the property, or the friend that somebody lets stay there, or whatever the case may be. Generally in these situations, nobody has a lease. They just are essentially squatters. And I know that none of my clients or beneficiaries ever understand why these people have any rights, but they do.
They do indeed. So what you're describing is more of like a tenancy at will. So under 789, that's terminable on a 30-day notice. But then where it can get more complicated is if they're in the city of San Diego or Chula Vista or any of these jurisdictions that have local just cause protections, you're still going to need a just cause basis for that eviction. You know, so there's a couple of ways to tackle it. You could just say, hey, it's an at will, you're not really a tenant, here's your 30 days and see where it goes. You could try an 827, probably not necessary, or pretend that, okay, you're month to month, and we'll just give you 60 days and list a just cause reason. That's probably the simplest way.
Probably the safest, right? Because
I tend to, sorry, I'm just reading the comment on the side. Okay. So you can chop this up, right? So I'll just say that I can give like I have a professional picture, maybe use that or something. I'm sorry that this keeps happening with the freezing. It's really distracting.
Don't worry, I got my own issues.
Okay.
Yeah, so it's out of our control.
Yes. So in regards to your question, I think that just doing a 60-day and giving them the benefit of the doubt that, okay, you're not month to month, but we'll just pretend you are, with a monthly rental payment of $0, and here's your just cause reason. And then, you know, you don't have to worry about a demur or affirmative defense at trial or something like, hey, you know, you didn't give us the requisite time. But I have seen judges say, hey, you're at will. There's no hiring of this real property under this at will relationship. And therefore, you know, 1946.2 and all this just cause stuff isn't going to apply to you. But at the end of the day, my assessment would be, yeah, you might get that, but what's an extra 30 days just not to have to worry about it?
Yeah, rather than go back to the drawing board. One of the things that I am often telling my clients as well is, don't do this notice that we're discussing on your own, because if that notice is defective, you have to start all over again as well, right?
1000%.
Yeah.
I often say to people, the notice is the seed that sprouts the case. And even attorneys who don't do eviction law shouldn't be doing notices, and then definitely not these like non-attorney eviction petition preparers, because people will often go there to try to save a buck up front, and that can have incredibly serious consequences. And the landlord too, you got to understand where they're coming from. So the cases move so slowly now. You could be 6 months in and then realize you didn't dot an I or cross a T on a notice.
Oh my gosh.
Start over.
Wow.
All this time not collecting rent. And that's, you know, the best way to head that off, talk to an eviction attorney up front, you know, have someone who knows what they're doing, prepare the notice.
Yeah.
And I would imagine the judges lean more towards the tenant who appears to be the, you know, the more fragile party to
Underdog. Yeah.
Is that true, or is that just a misconception?
It depends on the judge, I think, quite honestly. You know, everybody has their biases. I think most judges in San Diego do a good job of playing it down the middle. But the way eviction law is set up, right, it's strict statutory construction. So these are special summary proceedings limited to the right to possession of property and damages pertinent thereto. So the landlord can, I don't want to say always win, but as close to a sure thing in the law as you're going to have if they play their cards right. So there is kind of this hyper scrutiny on what the landlord did. And if one step is just kind of slightly off course, may not even seem like a very big deal, but that could be the factor that a judge hangs their hat on to not award you possession.
So if everything is done exactly to a T, you know, above board by the law, all the T's are crossed and I's are dotted, there is recourse for the landlord or the owner, correct? I mean, I always feel like, that there's an opportunity or chance that they're not going to succeed, but it sounds like as long as they're doing everything right, the law is going to support that.
Well, again, it's probably as close to a sure thing as you'll get in the legal business. You can't guarantee anything. And I guess the point I'm trying to make is far more cases go south for landlords because of some sort of technical issue or irregularity than where a tenant wins on the merits based on an affirmative defense. Now, that does happen. Landlords are not perfect. There's habitability, there's retaliation. Those are probably the two we see the most. And there's others. But in my experience, when a case goes sideways, it's usually because an I wasn't dotted, a T wasn't crossed, not because there's like merit to this affirmative defense. I mean, if the rent wasn't paid and you've got a ledger, the rent wasn't paid, right? It's more likely it goes wrong. The landlord, made a math error and overstated the rent amount by $10, and then you have to start over. If that answers your question.
Yeah, it does.
Wow. We've done this a few times in cases or attempted to. I don't know if we've actually been successful in some of the ones that we've worked on together, but where we kind of do cash for keys. Like, hey, we're going to give you money. You get out. We'll avoid this whole eviction proceeding. And two questions about that. One, should the notice still be provided, even if that's the plan? And two, should cash for keys be documented, legally, and everybody signs off on it?
Right. So I get this question and kind of questions about this all the time. So first, you got to know in San Diego now, to even have a conversation with the tenant about cash for keys, they have to sign a release. If you don't have them sign, and it has to be this exact language that the city council has given us. If they don't sign that and you have that conversation, you've committed a violation and can be sued.
Is that in relation to, I'm probably not going to use the right terms, but I heard that there was during COVID a new law about like emotional distress for the tenants.
This is purely, this is non-COVID. This was the new just cause San Diego residential tenant protection ordinance passed by the city of San Diego in June of 2023. So this is all post-COVID requirements. Some of it's similar to COVID in that they declare emergencies, right? There's a housing crisis and all this to, pass this legislation. Just like with COVID, right? SARS-CoV-2 emergency, and we need to do these moratoriums and different things. So like kind of the basis they're proceeding on is the same, but it really has nothing to do with COVID in terms of like cash for keys or emotional distress or anything like that. But the issue with the cash for keys also, because landlords do this all the time. I'm talking to clients and they just go, well, I don't want to do a notice. Like, can you just talk to them and see if they'll take the money and then we don't have to pay for court and all that? And I get it. I would probably wonder the same thing. The issue is, let's say your tenant says, okay, I'll leave for $5,000 in 60 days. All right. I'm just making it up. And you do a agreement for that. 61 days and they're still there. So now I go to court. Now I'm filing an eviction on that agreement, and those can be a little squirrely in that it's under 1161.5, but hey, they can argue, well, stuff wasn't properly served and things. It's not really a traditional notice or end of lease case. It's a breach of a contractual agreement to leave styled case, which is not the norm. And in my head, I strongly prefer, let's get the notice, let's file a lawsuit, and if we get that cash for keys deal done, Great. That's wonderful.
Mm.
And it'll be secured by a sheriff's lockout. So meaning you give them 60 days from that point. Well, the sheriff locks out at the end of the period, not we start in court at the end of the period. So for me, and I understand why clients want this, but you really are putting a lot of faith in that person to perform.
Mm-hmm.
And if they don't, you've just wasted a lot of time. So to me, I think it's usually better to do it in the context of a lawsuit so it can be secured by a lockout versus, okay, they're in breach, now I file my case.
Well, and I think at the point you're doing cash for keys, you probably have an issue with that tenant to begin with. So the fact you just mentioned putting a lot of faith in that person, it's probably not smart to do that.
Right. And the other tenants will often want the money up front, which is definitely not advisable,
Right.
because you could be out the time and the money and they're still there. And by the way, you just gave them money to pay for a lawyer. You know,
Right.
to me, you know, when cash for keys deals work, it's at the end. You meet at the property. Every time I've seen one where they try to meet somewhere else, it never works. At the property, at the agreed time, in the daytime. I won't be doing these things at 10 o'clock at night because people are always moving at the last minute. They're never finished. And you walk through, you make sure nobody flushed cement down the toilet, didn't burn anything. There's no one living there. They're out. And keys are exchanged for certified funds. I find that whenever you deviate from that, it tends to lead to trouble.
Yeah.
Okay.
I also learned recently, I think it was when we served the notice, we had to give money to the tenant. Can you talk about that a little bit? Because I'm not sure I even really recall the reason and the why and how much we were supposed to give them for what.
Sure. So that is something under the San Diego City Residential Tenant Protection Ordinance. There's one under state law we can talk about too, but to your question, the city of San Diego requires if it is a no fault just cause basis for the eviction, meaning I'm withdrawing the property from the market, my daughter's moving in, one of those types of reasons, you have to pay the tenant relocation assistance not less than 2 months rent, and if they're elderly or disabled, 3 months. Now, the definition of elderly and disabled, in my opinion, is so loose, like I didn't get a great night's sleep last night. Maybe that qualifies. And the last thing that I would ever want is, you know, in your special summary proceeding in a fast track trial, supposedly, you're having a fight with the tenant about their medical conditions. So generally, I just say do the 3 months. When you're in that situation, especially if it's one of these older leases with someone with below market rent, you know,
Which is usually the case in our situations.
Right.
Is the 3 months based on their current rent at that unit, at issue property, not their future rent, which is going to be much higher?
Correct. It's what they're paying now. So I've seen it, like you asked before about what about like the kid who never leaves, really at will. You know, I've seen notices they'll say, you know, 3 months relocation assistance of $0 because you're not paying any rent. You know, but generally, well, I should say, to answer your question, that's why that was done in that particular situation. From a state law perspective, so we're outside of the city of San Diego. We're not talking about Chula Vista. And Imperial Beach just passed a local one too. It hasn't gone into effect yet. So anywhere else in the county, you're essentially dealing with state law, and that is 1 month. And under either, you could do a check to the tenant and they still have to pay the rent, or you can waive the rent, or you can waive it. So usually if it's small dollar, people will tend to cut checks. It helps facilitate an exit. You know, you got someone at $4,000 or $5,000 a month, you're probably going to be doing a waiver under those circumstances if it's like a 60-day for withdrawal from the rental market.
Yeah. Yeah, that it's interesting because it's like, you know, I've worked with you on quite a few of these, and it's like every time we do and I learn something new about, because they're always different situations, which is like part of, you know, that's kind of how trust in the States is every case is a different situation. And so you learn new things, which is kind of one of the fun things I like about our jobs. But it seems to be the same way with what you do, is like everything's a little bit different. You know, even though you talk about it being very statutory and, you know, it's still a lot of variation, it seems like, in all of the situations.
Absolutely.
Yeah. And I probably should have started this in the beginning, but touching on this is, who is the person that's in control if like somebody dies? Because sometimes I've had people, not necessarily clients, but just people in general that are like, oh, well, grandma died, I'm going to go collect her rent, you know, but I'm like, well, wait, do you have any authority to collect that rent? You know, and I had some clients that were estate planning clients, and they were the tenants and their landlord died. And they said everybody in the family was coming to them for rent, and they didn't know who they were supposed to give it to. In which case I told them, wait to get a court order or notice of new management or whatever, you know, that form, and put the rent aside. But, you know, in order to collect rent, you have to have some legal authority, correct?
No, absolutely. So I would think that it could be handled in a couple of ways. One, if you have a property manager, it wouldn't matter if the owner passed away,
Right?
because the manager is already in place. And if it's a situation where, you know, mom's or dad is just managing it, then whoever's inheriting that property, I think, would be person in charge. So if there's like a clear estate plan to that effect, or a trust, right, then like I would think the trustee of the trust would be the person. But definitely you don't want to let time go by, because that's where a lot of things can go wrong. And I've dealt with a lot of these scenarios with you guys, with other trustees and fiduciaries. It comes up all the time, and it really compounds when you don't take action right away. Because, hey, things are getting figured out, and now a year's gone by and someone hasn't paid any rent, and now you get in, and like you can get, it wouldn't take much to get 2 years behind the 8 ball before you're doing anything, and now you've just made it, I should say, complicated the simple, right?
Yeah, right. It's the opposite of what we're trying to do.
Exactly. So I would say, you know, moving on it quickly with that notice of change in management is probably the best thing you could do.
Yeah, our probate judge used to say, let's not make a hard one out of an easy one. So,
right.
Yeah, exactly. You also mentioned earlier, you know, when you give the tenants money, then you're giving them money to pay for an attorney. Talk about that a little bit, because I know legal aid is one of the areas, this area of the law is one area where they're quite active on behalf of tenants.
Sure. So, yeah, of course, legal aid's, you know, not a paid service. It's technically paid for by the landlord out of their property taxes, but the legal aid usually doesn't get in until you're within the case. I've done cash for keys with legal aid before, and you know, they're fair stips, and a lot of times I welcome it, because you're dealing with an attorney on the other side that knows the ropes and what they're doing, versus a pro per who's, you know, hey, you know, my uncle said this, or I heard such and such and I want that. So kind of shifts the burden, you know, to them to control the situation and take some work off you. As far as private counsel goes, there's only a handful of tenant attorneys in town. There used to be more. For whatever reason, that well has just kind of dried up, so to speak. But certainly, you know, if the tenant retains the lawyer, then they have the absolute right to do that and present whatever defenses they have to your notice or the claim or anything else. Yeah, my comment was just more about, like, yeah, if you're paying them cash for keys up front and they don't leave, and you know, that could be potentially funding a defense. That's the consideration. And
I find that people are surprised that, you know, they're able to get free legal counsel through legal aid. You know, people are like, well, how do they get now they have this attorney, they can afford that. And I was like, well, you know, legal aid provides counsel, and you know, there's not a ton of areas under the law where that is the case, but this is one of them.
Absolutely. There's a clinic at the courthouse. So what happens a lot is tenants get served with the summons and complaint. It's now 10 days to respond. It used to be 5. So within 10 days, they'll show up at court, kind of not knowing what to do. And they're directed, oh, there's the legal aid office on the 2nd floor. And someone will help them check the boxes on the answer, so you can't take their default. And then whether or not they qualify for the legal aid attorney, it's income based, you know, whatever their metrics are. I believe it's 1 or 1.5 times the poverty line, but I'm not positive on that. But whatever the requirements are, if they meet them, then they can be assigned a legal aid attorney.
Yeah. So there's also often another complication that we have in our cases where the person living in the house might be a beneficiary of the trust. And so they have an interest in the property. And I know you have been involved in some of those cases.
Sure.
So what are those complications?
Well, unless they're the trustee, it doesn't matter, would be my response. You know, okay, they're a beneficiary, but more often than not, they just want to keep living there for free. So how can the trustee allow the estate to continue as is without getting rental income or selling the property? I would think letting that go on would be a breach of the trustee's fiduciary duties to all beneficiaries.
Yes.
So just because the tenant's a Benny wouldn't really change the analysis for me. You know, if the place needs to be sold because money needs to get cut up, well, they can do that, and the tenant can, beneficiary can get their piece at the end. But as you know, nobody wants to buy into a lawsuit, and you're not going to get market value with an occupied property. Plus, and I've seen in cases where people try to walk that line, then you're playing games with the tenant, trying to do showings and stuff, and they're not cooperating, and it just never works. So, I have seen pushback on this from the tenant bar. Some people are trying to argue that, well, withdrawal from the rental market doesn't mean you can evict somebody in order to sell, because how do you know that the buyer isn't going to be also rent the property? So, but I haven't seen courts down here grab on.
Yeah, that seems like a big, snake pit of issues.
Yeah.
No,
definitely.
And I've had a few realtors be like, oh, I can sell it with a tenant in there. I don't think it's ever actually worked out because, like you said, it's going to be way below market value because they know they either have a non-paying tenant that they have to get out, or, and have to face this whole eviction, or they're going to have to deal with that tenant one way or another.
Right. And, when I started this, about 18 years ago, it was not like it is now. Okay. So you in and out of a case, 60, 90 days, maybe $1,500 from the landlord was very regular. Now, double, triple that time. And same with the cost.
And that's been the case with our courts as well. I think it's a court issue, partially.
That's the biggest issue we're dealing with right now. And, I have to be careful. And it's true that there's a lot of dedicated public servants working very hard, and the courts are short-staffed and underfunded, and everyone's doing their best. So it's not a knock on them. But the reality is that forms and things that you would get back in a day or two now take as much as 6 weeks to process.
Mhm.
And I'm not talking about big ticket stuff, like an order to serve by postings about 6 weeks right now for a judge's signature. That used to be 48 hours,
Wow.
So it really slows the process. It makes it feel like a more complicated case, a heavier case. Again, it's definitely not how it kind of used to be. And I would say that's probably the biggest issue in the industry across the board.
Yeah,
is,
I would
is
imagine
managing the client through that, because someone may have tried to resolve it themselves for several months before even hiring a lawyer, so they're already pretty far in the hole. And I found, clients like during COVID were very, very receptive. Look, they changed the rules on us again. There's this delay. This is going on. There's this problem. And they got it, but in today's society, like, you tell people, I filed your order to post. We did the declaration of diligence. The process server was there the next day after the complaint issued. It doesn't click with them, right? The same way that they could understand why something got slowed down for COVID, something for like an administrative delay. It just,
and I feel like
we get it.
Like a lot of people may have expended a lot of patience during COVID because everybody just seems more short, tempered. Like people just don't seem to have a lot of patience lately, in general, I think. So maybe
we live in a very, everything on your phone happens so quick. So I think people expect everything to be that quick. Even, on our side, clients want to know if they can get their drafts, in 2 days. And it's like, this is our first call, we're not going to be able to get them to you that quickly. So it's just an expectation, and an unrealistic expectation.
Yeah. But the court, being so slow, I mean, it's the same with probates, they get slower and slower, and it's nothing we can do about it.
Sure. And you can set client expectations and tell them up front, and they can hear you, but until it happens to them, they don't get it, and I think that's human nature. And I agree with your point. I do think they feel more contentious now after COVID. People are, so that really, I think, more than anything in modern evictions, right? So a question I get all the time is like, are squatters' rights a thing? And no, they're not, but it can feel like it, because what should have, what 5-10 years ago was 60 days, now being 6-9 months and costing 3-4 times as much, feels like there's squatters' rights when really there's nothing objectively unreasonable about these just cause statutes when you go on. Some of the city stuff and the local things, I think, goes a little far in some aspects. But when you read these lists, like, okay, you need a reason. Somebody's been living there. Sounds about right. I mean, nothing. It's not so far out of left field, but the administration of it, the execution of it, it just, things can break down, and even with everybody dedicated and doing their best.
Yeah, no, absolutely. Well, I think we run out of time for today, but I think we covered a lot today. I really appreciate, you being here, and I appreciate all the help that you give us in our cases. These things crop up all the time, and we focus on trust and estates and not landlord tenant, and vice versa for you. So it works out really well. But yeah, thank you for being here, Lawrence, and for all your insight and expertise in this area.
Sure. Thanks for having me. My pleasure.
Yeah. Thanks to everybody who tuned in today. And hopefully you felt that we have simplified the complicated around a few issues with landlord tenant. Or maybe you discovered that it's more complicated than you thought it was. But you can find Lawrence at saferlaw.com, and you can find us at lawgbs.com. Again, thanks for joining us, Lawrence, and we'll see everybody on the next one.
Thanks, Lawrence.
Thank you. Take care. Bye-bye.
You've been tuning into Simplifying the Complicated with your hosts, Lori Bolander and Lauren Gallagher. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, lawgbs.com. Thank you for your positive feedback, comments, questions, and for sharing this show with others.